Hello, good morning, everybody. I'm really sorry for this delay. Now, the purpose of this today's meeting, which I just informed you, I thought about doing it to discuss about how to go around the judgments which has just been delivered day before yesterday by the Honorable Andhra Pradesh High Court, where the constitutional validity of Section 16(4) has been upheld. Now, the issues before the Honorable Andhra Pradesh High Court was the constitutional validity of Section 16(4), whether they are violative of Article 14, 19, 1G and Section 300A. The second point of discussion was the non-obstante clause in Section 16(2) of the AP GST and CGST Act, and whether it will prevail over Section 16(4). Then there was a notification issued by the government of Andhra Pradesh providing extension of time for filing returns. And lastly, it was argued that since the return in GSTR 3B has been accepted with a late fees, so whether that will exonerate the delay in claiming the ITC beyond the period specified in Section 16(4) of the GST Act. So the first point, before going into the constitutional validity issues as to what could have been the possible arguments which could have won the day or probably could have had a better result. But I think the first point which I need to talk about is whether the acceptance of GSTR 3B return beyond the date specified in Section 16(4) can exonerate the delay in claiming of the ITC. So this is very, very vital, the use of the word claiming of the ITC. I think most of you know the basic fundamental provision of Section 16(4), which I'm just talking about. Section 16(4) says, and let me just read out from Section 16 itself. So Section 16, subsection 4 says that a registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or services following the end of the financial year to which such invoice or debit note pertains. So effectively, if you claim or if you take ITC beyond a particular date specified in subsection 4, then your ITC becomes time barred. So the word which is used in Section 16 subsection 4 is taking of the credit. Now contrast it with Section 41, which talks about availment of input tax credit. Section 41 says that every registered person, subject to such conditions and restrictions as may be prescribed, be entitled to avail the credit of eligible input tax as self-assessed in his return, and such amount shall be credited to his electronic credit ledger. So now the key words are, in my view, Section 16(4) uses the word taking of the credit. Section 41, which talks about availing of the credit. So the key word in Section 41 is availing of the credit. And here again, it uses the word self-assessed. So what is the meaning of self-assessed? And then it says that he will be entitled to avail the input tax credit as self-assessed in his return. So first of all, the input tax credit is self-assessed. Then that credit, which is self-assessed, is availed in the return, and after it is availed in the return, it is credited to the electronic credit ledger. So what does all that mean? What is taking of the input tax credit? What is availing of the input tax? Are they synonymous terms or they are different terms? The purpose is different or the meaning is different. So now again, let us go to section 16 itself, which says that I am reading out section 16 subsection 1. It says that every registered person subject to such conditions and restrictions as may be prescribed. Now the conditions, where all they are prescribed, so conditions are prescribed in subsection 2, subsection 3, subsection 4. And I am not going to go into the issue of the non-obstante clause of section 2 also. I believe all of them are conditions which are prescribed. And conditions are some conditions with respect to documentary requirements and all which are procedural in nature. They are prescribed in rules also. So the substantive conditions are prescribed in section 16. Then there are conditions like the conditions wherein you cannot avail the credit or you partially avail the credit. They are specified in section 17. Then section 18 talks about credit in special circumstances. So all of them are conditions which are prescribed in law. So it says that every registered person subject to such conditions and restrictions as may be prescribed and in the manner specified in section 49 be entitled to take credit of input tax charge on any supply of goods or both which are used or intended to be used in the course or furtherance of his business, and the said amount shall be credited to electronic credit ledger. So here again, you see that this subsection, section 16, subsection 1 has two parts. One is that you are entitled to take input tax credit subject to such conditions and restrictions as may be specified. And one of the conditions is specified in section 16(1) itself, which says that it should be used in the course or furtherance of business. So this is the primary condition, that you use it in the course or furtherance of business, but there are other conditions also which you need to satisfy before you take the credit. So that is one part. Then the second part of it says that, and the credit which you have already taken shall be credited to the electronic credit ledger. So first you take the credit and then that credit is credited to the electronic credit ledger. So both are different, two separate events. Taking of the credit and availing of the credit are two different events, as can be understood from section 16 subsection 1, section 41 and section 16(4) itself. So what is the meaning of taking of the credit? Taking of the credit, in my view, is crediting the credit, taking the credit in your books of accounts. So my personal view is that if we are able to satisfy that I have taken the credit in my books of accounts within the timeline prescribed in section 16 subsection 4, then the timeline restriction which is provided in section 16 subsection 4 does not come in the way for delayed filing of the return. So the argument that just because I filed my return with delay and therefore I should be exonerated from the delay in claiming of the ITC beyond the period specified in section 16(4), that should never have been the argument, provided your books of accounts reflected the credit. So the appropriate word which have been used is, I have already claimed the credit. And once I have claimed the credit, then my statement of affairs, both with respect to my output tax liability as well as my input tax credit as per my books of accounts, I merely reflect my statement of affairs in the books of in the return. So return is only a mechanism to tell the government of my statement of affairs as per my books of accounts. And the law repeatedly uses the word self-assessed. And where will the self-assessment take place? self-assessment will take place in my books of accounts. I do self-assessment in the books of accounts. I examine whether I have satisfied section 16.2, section 16.1, section 16.3, section 16.4, section 17, section 18. On a combined conjoint reading of all these sections, if I'm satisfied that I'm eligible for credit, then I take credit in my books of accounts. And once I've taken the credit, then I tell the government that, look, this is what I have done. And now I'm informing you of my state of affairs. So in my view, the credit will be time barred only if the credit is not taken in the books of accounts. So this distinction, I believe, is very, very important. And this probably was not pointed out to the Honorable Court. And if in my view, if it was pointed out, then probably we could have had a different result. Now, my observation that claiming of the credit is part of the process of self-assessment and the credit is taken in the books of accounts is also, in my view, is to an extent reflected from section 35 itself, which says that every registered person shall keep and maintain at his principal place of business a true and correct account of production or manufacture of goods, inward and outward supply of goods, stock of goods. Then it also says input tax credit availed. So here also I am availing the credit. Here there be a little bit of conflict of the use of the term availing, but the point of the matter is that I need to maintain a books of accounts to take the credit. That is what the point which I wish to stress upon, that taking of the credit principally takes place in my books of accounts. So this is the the fundamental point which I wished to talk about. Then second point is that whatever I am saying, in my humble view, this is supported by a judgment of the Honorable Supreme Court in Union of India versus Bharti Airtel. Now, you will tell me that this judgment was in a different context. So let me tell you what was the context in which this judgment was delivered and why I'm saying that what I'm saying is supported by this judgment. So let me just allow me to share this particular judgment with you. Just give me a moment. I'm just opening it and I'm going to share with you the judgment of the Honorable Supreme Court in Union of India versus Bharti Airtel and why I'm saying that this is vital to defend my case and why this is vital to say what I'm saying. Just give me a moment.
Respected sir, I want to say something.
Yes. So section 16.4. Now let me tell you the background of this judgment. Now what has happened in this particular case is that the SAC omitted to take credit in a return which was filed for the month of August. Now SAC wanted to revise his return on the ground that at that point of time, it was for the period of July to September 2017. that he wanted to revise his return. And what was the basic background of trying to revise the return? The purpose was that the principal argument was that at that point of time, GSTR 2A was not notified. So therefore, I could not claim the credit, and it is because of your action that I could not claim the credit. So now I should be allowed to revise that GSTR 3B return, wherein I could not claim the credit. Now, in this background, the Honorable Court, Supreme Court made certain observations, which I believe are squarely applicable to the case which we are trying to defend under Section 16(4). Now, I am reading out from paragraph 33 onwards, few paragraphs I will read, and then you will agree with me that it fully supports the arguments which I am making. Paragraph 34. Is it visible properly to all of you? This
Yes, it is.
judgment which I have shared.
Yes, sir, it is.
I hope it is visible. So what it says, as per a scheme of 2017 Act, it is noticed that registered person is obliged to do self-assessment of ITC. I am reading out slowly. I will take 4 or 5 minutes to read it out, and then I think after that it will be very clear to you as to what is my principal argument.
Sir, on my screen, section 34 is not visible.
That the registered person is obliged to do self-assessment of ITC, reckon its eligibility to ITC and of OTL, including the balance amount lying in cash or credit letter, primarily on the basis of his office record and books of accounts, required to be statutorily preserved and updated from time to time. So what the Supreme Court is saying, that you are obliged to do self-assessment of ITC, and for that purpose, you are supposed to rely upon your books of accounts and record. And also you yourself reckon the eligibility to ITC also and output tax liability also. Further, it says that he could do even without the common electronic portal, as was being done in the past till recently pre-GST regime. As regards liability to pay OTL, that is on the basis of transactions affected during the relevant period giving rise to taxable event, the supply of goods and services become taxable in respect of which the registered person is obliged to maintain agreement, invoices, challans, and books of accounts, which can be manually maintained or electronically maintained. The common portal is only a facilitator to feed. So first of all, a common portal is a facilitator to feed also. So you feed the information, what is there in your books of accounts, or to retrieve such information. And it need not be the primary source for doing self-assessment. So your primary source of doing self-assessment is your books of account. The primary source is in the form of agreement, invoices, challan, receipts of goods and services, and books of accounts, which are maintained by the SSE manually, electronically. They are not within the control of tax authority. This was the arrangement even in the pre-GST regime, while discharging the obligation under the concerned legislation. The position is no different in the post-GST regime, both in the matter of doing self-assessment and regarding dealing with the eligibility to ITC and OTL. Indeed, that self-assessment and declaration would be anyway subject to verification by the tax authorities. The role of tax authority was come at the time of verification of declarations and return submitted filed by the registered person. Now, paragraph 34 says, Section 16 of the 2017 Act deals with eligibility of the registered person to take credit of input tax charged on any supply of goods or services to both which are used or intended to be used in the course or furtherance of his business. Now, mind it, it is breaking the Section 16 in two parts, as I just told you. What it says, the input tax credit is additionally recorded in the electronic credit ledger. So first you take the input tax credit in your books of accounts. You determine the eligibility. then it is additionally recorded in the electronic credit ledger. How it is recorded in the electronic credit ledger? Through filing of the GST 3B return. The manner in which the ITC may be availed. Section 41, subsection 1 emphasizes that every registered person shall be entitled to take credit of eligible input tax as self-assessed in his return, and such amount should be credited on a provisional basis to his electronic credit ledger. Now, what section 35 says? It further says, paragraph 35, as aforesaid, every assessee is under obligation to self-assess the eligible ITC under section 16 subsection 1 and 16 subsection 2 and credit the same in electronic credit ledger defined in section 246 read with section 49(2) of the 2017 Act. Only thereafter, section 59 steps in, whereunder the registered person is obliged to self-assess the taxes payable under the Act and furnish a return for each tax period as specified in the section 39 of the Act. To put it differently, for submitting return under section 59, it is the registered person who is to undertake necessary measures, including of maintenance of books of accounts for relevant period, either manually or electronically. So what it is saying, that first you self-assess, and section 59, which talks about obligation to self-assess the taxes and furnish a return, comes into the question only after you have done the self-assessment. And it further says that for submitting return under section 59, it is the registered person who is to undertake the necessary measures, including of maintaining books of accounts for the relevant period, either manually or electronically. On the basis of such primary material, self-assessment can be and ought to be done by the assessee about the eligibility and availing of ITC and OTL, which is reflected in periodical return to be filed under section 59. So you self-assess, and then the statement of affair is reflected in the periodical return. So this is a point I was trying to make. You can read the judgment on your own also. After you see, I conclude this. Now there are other points also on the constitutional validity aspect, which I would like to dwell some other time. But today, I would like to end this today's session with this thought, that the primary source of taking credit, so there is a difference between taking and availing credit. Taking credit happens in your books of accounts, and then availing credit happens through filing of the return. So only if you have failed to take credit in your books of accounts, then only the credit will not be admissible. Narendra Bhai, if you have any difference of opinion, then since you argued the matter, I was not aware. I'm really sincerely grateful that you have joined this today's talk. So if you can have your opinion about what I've said, what would you like to say? Or I mean, whether your arguments were not recorded. If they were not recorded, then you should go for review.
Sir, I'm very much thankful to you to meet you.
You please unmute yourself. Sir, kindly unmute yourself. We still can't hear you. You are muted. I think you need to increase the volume.
Increase the volume. Are you able to hear now, sir? Are you able to hear?
1 second, I can't hear you. Let me see. Yes, I can hear you now. Yes. Sorry, you are muted again. Muted.
No, sir.
Yes, yes.
And argue the case, whatever the decision you've taken this one, same play I've taken this one. And at the same time, because I mentioned underlying conditions, would like to bring the facts of that. It is not challenged with just like the 16.2 versus 16.4. It is challenged underlying condition under section 16.2, this one, read with COVID limitations, and as well as proceedings of the department, equality. And I taken the registration in month of March 2020, second half. Because of the COVID limitations, I closed my business, unable to access place of business, books of accounts, as well as my consultant. And in Anantapur town, many people are getting died every day. There is a fear. And one more thing, I would like to bring the fact is the government has given extension the returns for in the COVID period is the query. Sir, if you read the section, because notification, government issue a notification subject to conditional one for the waiver of interest and late fee. Suppose in case if I don't pay that, if we don't comply it, the due date 30th/6/2020 will not apply to me. It is applicable to me on 20th/4/2020. Section 39(5) deals about non-resident. Non-resident, in order to take registration, he need to appoint a local authority, local person. He is living in India. I am also living in India. Why is given exemption to him? And amnesty scheme. Many people done it amnesty scheme because government issued.
Narendra bhai, I asked you one thing, one very question which I want to ask to you.
One thing, sir.
Did you make any argument about the taking of the credit in the books of accounts in the first place?
Done, including only upon filing of the returns, the government not realize the revenue. I provided.
So did you file any written submission also?
Yes.
So and I think why don't you go for a review and say that this particular argument that the credit is taken in the books of accounts in the first place, that should be first of all looked into.
I want to bring your kind attention upon offsetting the liability. Suppose if you offset the liability on 15th of March, any particular period, even there is another step of procedure is there OTP, then or DSC, then only return will be submitted. And before filing of the submission, if I offset the liability on 15th, if I file on 20th, if 15th the government release the revenue, wait with the July 2017 return, government there is a clarification where you paid the tax 25th and file the return on 28th. Difference you need to pay the tax interest. So this plea also taken, and further rule cannot over the act. Section 164. If rule cannot over the act, form notified under the rules cannot over the rules, cannot over the act. Please look to Rule 69, Rule 73, Rule 75, Rule 77.
Narendra bhai, what I advise is that I will drop in my number in the chat box.
Yes,
so 1 second.
1 minute, sir. And I have your number. And at the same time, I bring your kind attention.
1 second. अरे ये 1 second.
কাকু খুব যন্ত্র লোক।
Sir, I think you might be receiving one WhatsApp message from me. Please go to the page number. This one, everything I mentioned it. Page number 25, para number 6.
Okay, I have received it. So Narendra bhai, we will have a private conversation about what to do, but in my view we should go for review.
Yes,
so with this I end this public session, then we'll continue with the discussion on in person.
Thank you, sir.
Thank you very much everybody.